the rule of the church. The church had its own set of rules. These rules guided the behavior of its members. They were important for maintaining order and harmony. The community followed these guidelines closely. They shaped the way people lived and interacted with one another. The Christians were a group of people who kept to themselves. Initially, this was due to fear. Later, it became a matter of strong belief. They removed all offending members from the community. This action cut them off from fellowship. It also deprived them of the rights that their beliefs considered necessary for salvation. This practice of excluding individuals from communion began as a strong spiritual tool among believers. Over time, we will observe how it evolved when Christians gained the ability to wield temporal power. In the early days, they formed a world within the world. They held strong convictions. Persecutions motivated them. They were very well organized. The bishops handled ecclesiastical matters and civil disputes. They ruled for those who preferred not to go to secular courts. They likely judged their own followers before regular ecclesiastical courts were established. Since apostolic times, they opposed going to external tribunals. In various councils, the Church prohibited appeals to civil authorities against Christian court decisions. According to the 87th canon of the Fourth Council of Carthage, established in AD 398, no Catholic was to bring any case, just or unjust, before a heretical judge. The time arrived when the state embraced Christianity. This religion began to shape the laws. Under Constantine, civil officers had to follow the decrees of Christian bishops. These bishops held significant authority. In 376, the courts were given the same status as the imperial magistrates. From the beginning, under the Theodosian and Justinian codes, bishops held significant disciplinary powers. After Charlemagne's death, during a time of violence and disruption, the ecclesiastical courts became firmly established. Over the centuries, they gained more power. They had their own rules and codes to determine cases. They adjudicated many matters, including tithes, breaches of covenant, births, marriages, and wills. In ancient times, it was a custom for the bishop to travel through his diocese. As he entered each parish, the inhabitants would greet him. From among them, he would choose 7 men of mature age and strong character. These men were then sworn on holy relics to share all they knew, or perhaps imagined, about their neighbors and their shortcomings. The bishop or his archdeacon would investigate. They would summon suspected persons for examination and sentence. These inquisitions with the testes synodales could be very harsh. They were often led by a watchful and critical Christian moralist. A bishop of Lincoln was very active in his diocese. He conducted thorough and detailed investigations. These efforts revealed many scandals among the people. As a result, he faced intervention from Henry III. The nations and laws of Europe changed from paganism to Christianity. The Church, with its strong claims and knowledgeable leaders, sought independence. The Apostle Paul mentioned that they would judge angels. He also said that the saints would one day judge the world. It was simple to assert that Emperor Constantine stated at the Council of Nicaea in AD 325 that priests could be judged by God, but not by men. The clergy wished to be judged by their own. They viewed the other courts with suspicion. The era was marked by violence. Punishments were often brutal. The lay lords and judges were greedy. While open pagans were no longer in power, new heretics emerged, drawing similar disdain. the Church began a long struggle. There were many conflicts. Some places saw victories, while others faced defeats. In the earlier period, the state held more power. A law from Gratian in the 4th century assigned most offenses of the clergy to the secular court, except for minor ones. At the Council of Agde in 506, it was established that the clergy should not appeal to civil power as plaintiffs. This was reiterated at the Council of Epaone in 517. However, they were required to attend if summoned to the secular courts. In 581, a council took place in Macon. It was suggested that criminal cases would be handed over to them. The clergy were not allowed to accuse each other in front of civil magistrates. The fear and jealousy of the secular courts continued. A canon from the Third Council of Orleans, held in AD 538, stated that a bishop's permission was required for a cleric to attend and as a plaintiff or defendant. In the Fourth Canon of the Fifth Council of Paris, held in AD 615, it was stated that no judge could try an ecclesiastic without first notifying his ordinary. This rule was reiterated in a capitulary of Charlemagne from AD 769. Pope Gregory the Great lived from 540 to 604. He argued that a clerical defendant should be tried by his own court. This principle was established by the Welsh canons in the 7th century. A capitulary of Charlemagne granted bishops the authority to judge clergy in criminal matters. However, the emperor kept the final say in all cases. By the year 853, his grandson, Charles the Bald, sought the bishop's help at Soissons. He was addressing accusations against a humble clerk who was said to have forged the royal signature. Pope Nicholas I, in his advice to the Bulgarians, stated that laymen should not scrutinize or condemn priests. He said that priests were to be under the control of their prelates. In 877, the Council of Ravenna made a decision. They ordered that those under the protection of bishops should not be taken by secular authorities. The two systems moved further apart. Clerks were not allowed to attend secular summonses, facing penalties if they did. The Emperor Frederick II decreed in 1220 that no one could drag a clerk before a secular tribunal. Any lay judge who convicted a clerk would lose his position and face spiritual penalties. The Emperor, Charles IV. In 1359, similar laws were established. These laws stated that imprisoning a clerk would result in outlawry and the loss of possessions. Pope Martin V confirmed this in 1418. In 1563, the 25th session of the General Council of Trent reaffirmed the right to clerical immunity. The Church had been permitted and designated to oversee the faith and morals of all people. It claimed the right to demand all clerics accused of crimes. This did not apply in cases of high treason, highway robbery, and deliberate house burning. It also excluded offenses against the laws of the forest, such as hunting the king's deer, and minor misdemeanors. Over time, all clerks sought the privilege of clergy. This included not only those in priestly orders, but also those who were tonsured and had their hair cut in the clerical style. Those involved in church work, like readers, acolytes, and doorkeepers, could claim the status of clergy. This status was often sought by very humble individuals, both rightly and wrongly. The presence of the tonsure and its authenticity played a significant role in legal matters. It was sometimes seen as a claim to immunity. In some cases, prosecutors would shave the heads of the accused to remove this sign. In the year 1350, a law known as pro clero was established. This law stated that all clerks, whether secular or religious, who were found guilty of treason or felony against anyone other than the king, would have the right to seek refuge in Holy Church. They would be handed over to their church leaders without any hindrance or delay. This law effectively granted immunity to those who could read. A man who claimed to be a member of the clergy was examined about his knowledge. He was asked to read a passage, often from the 51st Psalm. This passage was known as his neck verse. The lay court then asked the bishop's representative, does he read like a cleric? Legit or non-legit, the examiner would say. The person would then be sent to the ordinary or face a sentence from the judge, who was not allowed to teach an accused person their letters while they waited for trial. They might spend 5 or 6 years in the bishop's prison before appearing at the assizes. Foreigners could read from books in their own language. The blind could claim clerkship if they spoke in Latin. Being tried by the ecclesiastical courts was seen as a privilege by the accused. They had the opportunity to prove their innocence through canonical purgation. Even if they were condemned by a bishop or abbot, this could happen if they could not find the necessary compurgators, or if they were not allowed to make their purgation. In some cases, if they refused to swear their innocence due to religious fears, the punishments from the church were usually merciful. This was not the case for serious sins like heresy or witchcraft. The canons forbade the clergy from imposing death or mutilation. Archbishop Echbert repeated this rule. In 1175, Archbishop Richard wrote that any priest who took the office of sheriff or reeve would face anathema. Again, in 1215, the clergy were prohibited from judging blood cases. A council of Toledo stated that they should not sit as judges in treason cases, even if commanded by a ruler, unless the ruler promised to remove the harsh penalties. At the Council of Auxerre, the clergy were not allowed to witness the usual torturing of prisoners. They were also prohibited from lingering around the Tropalium during its execution. The Church was generally more lenient than the medieval state. It only deemed certain acts or thoughts as high crimes against the soul. The Church could not use the harsh punishments of that time. Instead, it developed a different way to express disapproval. This led to the creation of penitential discipline. Initially, it used only spiritual weapons. These weapons were fearsome, even if they were not physical. By denying access to the church or communion, it seemed to close the everlasting doors on kings. This often brought the most powerful rulers to their knees, begging for forgiveness from God's priests. When someone confessed a crime or faced condemnation, they were given various tasks and burdens to bear as part of their penance. At times, the rules were strange and poetic. If a man killed a family member, the weapon used could be turned into a chain for punishment. He would wear this chain and, dressed in a specific way, would walk to a destination. This could be a local shrine or a faraway place like Compostela, Rome, or Palestine. Most people seeking forgiveness did not wear chains. They often went unarmed, avoided meat and strong drinks, and did not take warm baths. Sometimes they had to follow unusual and difficult rules set by their spiritual guides. For example, Robert, known as the Devil, was told by a hermit to eat only scraps meant for dogs and to act as if he were mad. King Edgar was not allowed to wear his crown for 7 years. Many examples can be given. They can go on and on. A common method of correction involved imposing penitential fasts. During these fasts, the offender had to live on bread and water. They faced many restrictions and disabilities. The sentences could last from 1 day to 20 years or more. Throughout this time, the penitent was expected to endure shame and disgrace, praying for your deliverance. The Church recognized class distinctions in various ways. Offenses were punished based on the rank of the victim. For example, the penance for killing a bishop could last 12 to 14 years, or even longer, involving only bread and water. In contrast, the murder of a deacon required 7 to 10 years of penance, while the slaying of a layman could be atoned for with 4, 5, or 7 years of discipline. People, especially the clergy, faced harsher sentences based on their rank. For homicide, a layman might receive 4 or 5 years of penance. A clerk would get 6 years, a priest 10 years, and a bishop could face 12 years, with 7 of those on bread and water. These lengthy penances seemed severe and were indeed challenging for devout believers. The Roman Church was well organized. It allowed its bishops considerable freedom in imposing and removing penances. "I do not need time to continue," said Chrysostom, "but I need the soul to be corrected. Show your remorse, show your change, and everything will be resolved." The councils had the power to change sentences. They could make them harsher or lighter, so that those who were weak or overly sensitive could have their tasks adjusted. They treated the strong with care. The wind was gentle for the soft lamb. In the 8th century, Cuthbert's canons at Cloves Hoo allowed the wealthy to send others on pilgrimages. This led to the rise of professional pilgrims. They could atone for their sins through giving money and donations. Ambrose had noted long ago that money could buy forgiveness. He said, "The Lord is not for sale, but thou thyself art for sale. Restore yourself through your actions. Use your money to redeem yourself." This instruction was followed and interpreted in the simplest way in the canons created, likely by Dunstan, during King Edgar's reign in the year 963. When a notable person was sentenced to fast for 7 years, he was to put down his weapons. He would take a staff in his hand and walk barefoot, wearing wool or haircloth. For 3 days he was not to sleep in a bed or attend a banquet. He was to take 12 men with him. They would fast for 3 days on bread, raw herbs, and water. In total, they kept 36 fasts. He gathered 7 groups of 120 men. They were to fast for 3 days. This resulted in 7 times, 120 times, 3 plus 36 fasts. The total came to 2556 fasts. This number matched the days in 7 years, including a leap year. His penance was completed, or perhaps avoided. The Church often enforced its penalties. Heretics faced severe laws. Even in England, civil forces would capture them and burn them alive. Anyone who offended against the canons and refused to do penance could face excommunication. This meant they were subject to arrest. In this country, if the offender ignored the excommunication for 40 days, the king's court would act. At the bishop's request, they would issue a writ of significavit, or a similar order. This directed the sheriff to imprison the offender until they had met the church's demands. The hierarchy could not directly impose severe penalties like death or amputation. Instead, they used various forms of corporal punishment. Floggings for penance or discipline happened often. The younger monks in the monasteries usually received 39 stripes. The bishops had other penalties ready. They used imprisonment as a form of punishment, unlike the secular rulers. The Catholic Church had ideals of cloistered life and ascetic seclusion. It aimed to create remorse through mental affliction. In its high-walled abbeys and gloomy courts, there were buildings ready to confine anyone. The first cells were located in the exedre of round churches and bishops' houses. They were known as the decanica. Monks who did not follow the rules were often imprisoned in the large monasteries. The ecclesiastical punishments were often seen as merciful. English comments will show this later. However, at times, they could be quite harsh, especially towards heretics. The Inquisition had its own prisons. In these places, it tortured its victims in many ways. The effects of solitary confinement were likely first noted here and were used to their advantage. In the 13th century, authorities were concerned about prison association. In 1229, a council of Toulouse decided that the converted heretics, those who had recanted out of fear of execution, should be kept separate. These individuals were sentenced to life imprisonment to prevent them from corrupting others. The Church and the Inquisition ordered the construction of new prisons. These prisons included small dark dungeons for solitary confinement. In 1246, a council of Béziers decided that the captives should be kept apart in hidden cells. This was to ensure that no one could influence another. It refers to the enormous rigor of the prison. The prisoners of the Church faced different types of confinement. There was the murus largus, where they could move about. The murus strictus, durus, or arctus confined them in separate cells with only bread and water. The murus strictissimus kept them in dungeons, bound in heavy irons. The Inquisition used many tortures, but learned little from Dante's visions. This organization has its own history. The bishops had their own prisons. The large convents also had cells for punishment. They used these places to impose penance. In 1077, at Canossa, Pope Gregory VII placed the rebellious German prelates in solitary cells. They received only bread and water. Another example can be found in the year 1283. A certain brother John bit his prior's finger. It was said, he did so like a dog. The bishop ordered the prior to keep brother John in prison. He was to be held in iron chains. His diet would consist of bread, indifferent ale, pottage, and a small amount of meat or fish. On the 6th day, he would have none. This was to continue until he showed repentance. A worse fate befell Alexander de Langley in the same century. He was a cultured man and the keeper of the abbot's seal. He experienced a state of extreme exaltation. This may have been due to approaching general paralysis or another form of insanity. Some might have seen his behavior as mutinous or blasphemous. He received a severe flogging. This did not restore his sense of proportion. He was then placed in fetters and sent to a cell. There, he ultimately died. His body was buried, still chained. Within the monasteries, there was a severe punishment called in pace. It involved solitary confinement. Dr. Leah states, those subjected to it died in all the agonies of despair. In 1350, the Archbishop of Toulouse asked King John for help. He wanted to ease the situation. The king then made a rule. The head of the convent would visit the prisoners twice a month. He would offer them comfort. The prisoners could also request to see a monk twice a month. This small change faced strong opposition from the Dominicans and Franciscans. They appealed to Pope Clement VI, but their efforts were unsuccessful. Abuses and cruelties could exist in ecclesiastical prisons. This often happens where high walls hide the truth. For example, we can find records that in A.D., in 1283, certain monks were taken by the abbot of Westminster. They were beaten severely, and one of them died as a result. There were instances when the church chose to degrade individuals from their orders. In the early days, this often meant that degraded clerics were quickly taken by the secular authorities. They were assigned to servile tasks. After this, they could not be reinstated. They were often confined in monasteries. This was a choice favored by the bishops over sending them to face punishment from lay authorities. Innocent III. From 1198 to 1216, it was directed that clergy who had been degraded should be handed over to the secular powers. In practice, clerks were not usually completely degraded. Being deprived of orders was seen as a severe punishment. It meant being cast out from the community and was done with great care. 3 bishops were needed to degrade a deacon. 6 were required to unfrock a priest. 12 prelates were necessary to judge a bishop. When individuals were degraded, excommunicated, and sent to the secular authorities, severe penalties were applied. The main reason the Church withdrew its protection was for persistent or repeated heresy. In earlier times, those found guilty faced branding on the forehead. They were often cast out, as was the case in Oxford, where some died from cold and starvation. Others were excommunicated, imprisoned, or had their property taken away. As militant sects grew in number, the Church encouraged the state to take stronger actions. Heretics faced severe punishment. They were often burnt alive, a practice that became common. This treatment was similar to the lynching of criminals in the United States. Over time, it gained formal recognition. In 1197, Pedro of Aragon and Emperor Frederick II were involved in this practice. In 1238, the Edict of Cremona was issued by Louis IX. In France, the établissements were established in 1270. Henry IV of England, in 1400, declared burning at the stake as the rightful punishment for those who were persistent or relapsed heretics. It was not the strictness of the Church that stirred jealousy and opposition from the secular power. The immunity provided to those under its protection led the state to challenge clerical privileges. Over time, these privileges were completely removed. In Saxon times, lay and church authorities worked together. However, William of Normandy changed this. He separated the church courts from the secular courts. King Henry II. He became king after a time of civil war and widespread banditry. During this chaos, the church strengthened its influence and expanded its authority. He aimed to restore the power of the central government. He discovered that the clergy and the clerks were beyond his control. In the Middle Ages, they formed a large group. Many individuals entered the orders despite having little connection to their original professions. They were often restricted from earning a living in other ways. Therefore, the king worked hard to bring the clerks under the authority of his justices. A significant case emerged in the year 1163. A man named Philip de Broye or de Broye was likely an archdeacon of Bedford and a canon of Lincoln. He had previously avoided punishment for a charge of manslaughter. Later, Simon Fitzpeter, one of the king's justices, accused him of murder. He protested strongly and spoke harshly to the judge. At that time, there were several notable cases. One involved a cleric from Worcester accused of murder and rape. Another case came from Salisbury, where the offender received only imprisonment. King Henry reacted with great anger. He felt insulted by the actions against his delegate. He ordered that de Broye face trial, not only for the insult, but also for the original manslaughter. He intended to send him to the gallows. The archbishop did not want to reopen the case that had already been decided. The rebellious priest had insulted the king's officer. As a result, he was punished. He was stripped and flogged in front of the angry judge. He lost his office and stipend and was banished for 2 years. The king was not pleased. He wanted nothing less than the death of the canon. He took strong actions to control the clergy. In 1164, he issued the Constitutions of Clarendon. He wanted criminous clerks to face lay penalties. The offender was first accused in the temporal court. Then they were tried and convicted by the Ecclesiastical tribunal. After that, they were sent back to the secular court to receive the usual harsh punishments. Archbishop Becket and the English hierarchy believed that degrading a clerk and then sending him to secular judges was unfair. They argued that it punished him twice for the same offense. They referenced a Hebrew prophet, stating that affliction shall not rise up a second time. They agreed only that if a clerk, after being degraded, committed the same offense again, he could be treated as an ordinary layman. The death of Archbishop Thomas halted all of Henry's plans concerning the church. The temporal courts kept their right to bring the criminous clerk before them. They gave up their right to punish the degraded clerk. In the 13th century, it became the custom for the clerk to be indicted and inquired upon before claiming his clergy. By the reign of Henry VI, 1422-1461, he had to be convicted first before being handed over to his bishop. In 1261, Archbishop Boniface ordered that clerks held by their bishops for serious crimes should face perpetual imprisonment. In the year 1275, Edward I, it was ordered that bishops should not allow any clerks to leave without purification. In 1276, those who had been married twice or had married widows were not allowed to claim clergy. In 1279, Archbishop Peckham issued a decree. He stated that clerks in prison for their crimes should not be released easily. They should not be admitted to purification on minor grounds. The process should be serious and careful, respecting the king's authority and the principles of fairness. In the year 1350, the statute pro clero was introduced. It seems that many individuals had been taken by the secular authorities. This act reaffirmed the church's privileges. The clerks who had offended were to be handed over to the spiritual courts. For this grant, the king required that the clerical convicts be kept safe and punished properly. He wanted to ensure that no clerk would feel emboldened to offend due to a lack of correction. Urged by the crown, and perhaps worried about further laws, Simon Islip, Archbishop of Canterbury, tried to make conditions tougher for the church's prisoners. They are, he complains, with so much backwardness they are committed to jail. They are fed so well there that the prison, meant as punishment for their crimes, becomes a place of comfort. They are indulged in their vices by ease and such temptations, yet they still manage to escape from custody, which is harmful to them. Some criminals known for their terrible deeds often find it easy to escape punishment. Each clerk released by the secular judge believes they can return to their old ways, one way or another. We have decided to make rules about the imprisoned clerks. They are to be closely imprisoned with proper care and speed. This is according to their status and the seriousness of their crimes. The aim is to prevent them from returning to their former ways, which would bring shame to the church. Clerks who commit serious offenses will receive only bread and water on Wednesday, Friday, and Saturday. On other days, they will have bread and small beer. However, on the Lord's Day, they will receive bread, beer, and pulse in honor of that day. They were instructed not to receive any alms or gratuities from friends or acquaintances for any reason. No exceptions were allowed. These strict rules, issued by the archbishop, were echoed by all the prelates. They mirrored the harsh disciplinary systems that became most severe in the 19th century. The Church's treatment of its prisoners was generally mild and humane. This belief is supported by various reasons. The clergy were not prison officials. Their role was spiritual, not military. They interacted with men of similar status. They often showed loyalty to their class. After Islip's ordinance, there was criticism and new laws. It appears that the Church's convicts received better treatment than the laymen in the common jails. Prisoners were often treated with a sense of humanity. Bishops preferred not to pay for their upkeep. Therefore, long sentences were avoided. Life sentences were rare. On special occasions, prisoners could be pardoned. Friends sometimes paid ransoms for their release, which could be around £20 or £40. The state consistently showed a preference for severity. From the 13th century, it regularly sent clerks to their bishop without the chance for purgation. In theory, these clerks were to be life prisoners. If an ordinary tried to release such individuals, a writ from the chancery could prevent this action. In the year 1238, a bishop of Exeter faced difficulties. He had sent a certain clerk for purgation. Later, an abbot of St. Albans was accused of letting some prisoners escape. There were likely other similar cases. Prisoners of the bishops were often released. In the year 1402, a special statute was passed. This law stated that clerks found guilty of lesser treason, or known as common thieves, could not seek any form of purgation. In 1485, an act was passed. This act allowed bishops to commit priests, clerks, and religious men to ward and prison for offenses such as adultery, fornication, incest, or other forms of sexual misconduct. The bishops were not held liable for wrongful imprisonment. In 1487, a significant challenge was directed at immunity. By this act, clerks who could read but were not in orders could enjoy their privilege only once. To prevent them from being continually admitted after offenses, it was decided that clerks, not in orders, convicted of murder, would be branded by the jailer in open court with the letter M on their left thumb. If found guilty of theft, they would receive the letter T before being handed over to the ordinary's officer. An ordained priest could appeal to his church again. If he claimed his clergy a second time, he needed to have his letters of ordination ready. He might be allowed one day to obtain them, or get equivalent evidence from the nearest bishop. If he could not provide them, he would lose all clerical privileges. In 1496, lay persons who murdered their lord, master, or sovereign were deprived of their clergy. In the 4th year of the next reign, more exceptions were made. Clergy was taken from anyone not actually within orders who committed a felony in a church, on the king's highway, or who killed someone in his own house. A clerk, especially a priest, faced great difficulty in being degraded and cast out of orders. This process was not easy. To fix this, Cardinal Wolsey was the Archbishop of York. He received a bull from Pope Clement VII that was relevant to England. In 1528, a single bishop could perform the ceremony. He was assisted by 2 abbots or other high dignitaries. The law, known as 23 Hen, was established in a specific historical context. It played a role in shaping legal practices of the time. 8c. In 1531, there is a reference to the warning given by Edward I. In 1275, a decree was made. It stated that no church prisoner should leave without strict purgation. This was during the time of Henry VIII. It is noted that they were released quite easily. It refers to the law established by Henry IV. In 1402, a decree was issued. It stated that notorious criminals should not be allowed to make purgation. The document noted that ordinaries were quickly releasing offenders. This was done hastily, often for reasons of corruption and profit. The clergy refused to take responsibility for the prisoners. The law removes the benefit of clergy from certain petty treasons and from arson. This change applies to all clerks, except for subdeacons and those in higher ranks. The clergy in the orders faced lifelong imprisonment for these crimes. In 1551, during the 13th session of the Council of Trent, the 4th canon was established. It stated that a bishop or his vicar general had the authority to condemn and degrade clergy who committed crimes. This action could be taken with the help of several mitred abbots, or, if they were not available, by high ecclesiastics equivalent to the number of bishops in the previous system. Le Courrier, page 550, Luzio, Catholic, Encyclopedia. 4. They needed to find guarantees for good conduct. The accused was required to provide £40, along with 2 substantial sureties of £20 each. The statute aimed to ease the burden on bishops regarding their prisoners. It allowed them to degrade offending clerks. They could then hand these clerks over to the king's bench for safekeeping. A certificate would confirm their degradation. The king's judges would then pass sentences, often death, as if the accused had been laymen at the time of their accusation. In the year 1531, an act was passed. This act stated that escapes from the bishop's prison would be considered a felony for the clerks. Those who were within orders would be returned to their prison. They were to remain there without the chance of release. In 1533, clergy was removed from those who refused to plead. It was also taken from those who challenged more than 20 jurymen without cause. In 1536, clergymen in religious orders were to be treated like other clerks. However, this law lasted only about 10 years. The immunity of the clergy started to diminish. A series of laws emerged. These laws exempted certain crimes from any leniency. In 1576, convicted clerks stopped being given to the bishops for purgation. For all felonies that could involve clergy, lords of Parliament and clergy in orders were released immediately, even if they could not read. Those who could read faced a first offense by being branded. The court could also decide to keep them in prison for up to a year. Those who could not read were quickly hanged. As the value of clergy privileges diminished, they were extended. In 1547, this included bigamy, or those who had married twice. By 1692, it also included women, as professed nuns had always lived under the Church's rule. Once convicted, they would receive the same treatment as the men in similar situations. This meant they would be branded on the hand and then released. They could be discharged immediately or after serving a maximum of 1 year in prison. In 1699, it was decided that branding should occur on the face. This harsh marking made it difficult for victims to find work and left them in despair. As a result, the law was repealed 6 years later, during Anne's reign. In 1705, the reading test was no longer required. The distinction was made between offenses, not offenders. Those convicted of minor felonies could still be admitted to clergy. The Act of 1705 stated that these convicts could be sent to houses of correction or public workhouses. They could be held for a minimum of 6 months and a maximum of 2 years, depending on the magistrate's decision. In 1717, a law was passed. It stated that individuals, except for peers or clerks, who committed clergyable offenses, could be transported for 7 years. This was a shorter sentence than the usual 14 years. In 1779, another law was introduced. It allowed those who faced the punishment of being burnt in the hand to choose a fine instead. They could also be whipped, but not more than 3 times. Women were to be flogged only in the presence of other women. This act ended the practice of branding. About 50 years later, during the reign of George IV, the last remnants of the old privilege were removed. For many years, people have criticized the old rights given to clerkship. They believed these rights violated the idea that all men should be equal under the law. However, when we look at the harsh acts they helped prevent, we might see things differently. After considering the pointless nature of simple punishments, we may conclude that these rights were not entirely bad. In fact, they may have contributed to a greater good.